Hello and welcome to Runkle of the Bailey. Sorry, I just had to fix my tech on that because I hadn't added myself to my own stream. That was not wise. So, how's everyone doing? And how's the audio? Where's everyone chiming in from? Sorry I'm late. I don't know. I've been mentioning on Twitter. I've decided to start a little portable bar project to make a little leather kit that is like a bar I can take around if I feel like it. So I just got in an 8-pack of hip flasks. So I thought I pretty much had to fill one. All right. So I see here Pictou, Nova Scotia. Somebody from Seychelles, Massachusetts, Scotland. Wow. Okay, that's a long distance away here. Australia, Jacksonville. So, all right, lots of people from all over the place. So, first of all, I guess I just want to talk about what this is and what it isn't, because the media, as per usual, has been not exactly the best at reporting what's going on. So, they've been basically saying, "Oh, the briefs are in. The briefs are in." And I thought, that's weird because the briefs aren't due for like a month. And I see Secret McSquirrel saying, I'm Scotland, right? Yes. And we'll have to get that going. Normandy, France, from the land of thank F it's Friday. Nice. So, and I see Scott Cardinal saying, I just had to subscribe to your channel. That's not suspicious, is it? Yeah, YouTube does this thing every once in a while where they unsubscribe people or they shut off the notifications. So check that subscribe indicator, and if it's not on, click the button. And yeah, also do all the usual sort of YouTube things. Hit the like button, hit the all of that stuff. I should probably share this just so that people know that I'm live right now. But yeah, so the media has. I saw a lot of reports saying, this is the briefs, and I thought that's weird. They've got like a month to get those in, and if you haven't worked in law, lawyers are busy, and so it's unlikely. It seems like it would be really weird for everybody to get their stuff in a month early. That just seemed super weird. And of course, it turns out that that's not what was happening at all, because of course it wasn't. So all of this is the designation of assignments of error. And what that means is basically they're just telling the court in advance, hey, these are the issues that we are going to be arguing. These are the live issues that are going to be up in the appeal. So we're not going to get the full argument at this point, which is going to make assessing some of these things somewhat challenging, but we're going to go through them and have a look at them, and sort of I'll explain what they are and give my best guess as to what things are going to happen. I see somebody saying, do you get extra points for filing things early? No. It is, if you're in the legal profession, it can be a good idea to file things early, but that's mostly just in case you have problems. Like often you'll write your thing, you think it's perfect, you take it in to get filed, and they're like, hey, you've put the wrong color cover on this, and then it doesn't get filed. It's really nice if you've got like, oh, well, we've got 3 days to fix this, rather than, oh, we've got like 30 minutes to fix this. So there is no extra credit, but it can be helpful. All right, so let's see if I can bring this up here just to show you guys what we're looking at. Sorry, it's just going to take me a second here as I wrestle with StreamYard and all of its wonderfulness. All right, let's try to zoom this in a little bit. So we've got, this is the appellant's designation of assignment of error, but keep in mind, we've got appeals from both sides. So in this case, this is Amber Heard's. And let's just go through, before we look at any of these, and just count them, because this is, I got a point about this. So 1, 2, 3, and then it continues on the next page. through 11, 16 in total. Now let's just talk a little bit about sort of appellate strategy. Hey, we got Hogue in the chat. Nice to have you here. Usually on an appeal, you want to bring a few issues. Usually you want like your 1 to 5 best issues. If you're bringing 16, there's one of two things I think is going on here. One, either your case isn't that good and you're just looking at kind of throwing everything at the wall to see if anything will stick. Or the other possibility there is maybe you've got some other reason to be throwing all this stuff in. And I've mentioned this before, that there's really two cases going on with the whole Depp and Heard thing. And one of those cases is the court case, the actual court battle. But the other case is a PR case. And I think that there's some real PR issues happening here. I think that we're going to see some of this litigated as a PR campaign, because otherwise throwing 16 issues in, that seems excessive. Liz J, thank you for the new membership. And yeah, we'll go through and have a look at this. So, all right. So first, trial court erred in declining to dismiss the action on the ground of forum non-convenience. So basically, what they're saying is this is a jurisdiction question. They should have thrown this out because they sued in the wrong place. Okay, I mean, that's an argument, but I don't think it's going to be the strongest argument here. And this is, I mean, not sort of the ideal thing there, but okay. Next one is erred in denying the supplemental plea in bar and in ruling that the November 2, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division, which would now be King's Bench Division because things have changed since then, in Depp v. News Group newspapers et al., does not foreclose Mr. Depp's claims. Now, I think this one's super weak. And that's just because Ms. Heard wasn't the defendant in that one. So, I mean, sure, you try to say, hey, this has already been heard and so forth, but sorry about the pun there. That was unintentional. But I don't think that they're likely to give this much credence, but we'll see there. Erred in denying the demurrer and plea in bar and in ruling as a matter of law that 3 allegedly defamatory statements in the challenge op-ed are A, actionable as statements of fact rather than non-actionable expressions of opinion, and B, actionable as defamation by implication. This one seems really... I mean, if you say that you were abused, that is a statement of fact, not a statement of opinion, right? You're saying actual things happened. And if you're implying that that abuse is in specific, particular fashions, then yes. And the actionable as defamation by implication, defamation by implication is not a new concept. It's not like they invented this specifically for the Depp trial. You can't just be like, well, I didn't mention their name, hint, hint, so long as it's obvious who it is, right? Like if I go and say, hey, and, Hogue was in the chat, so I'll call him out. Let's say I'm bashing Hogue and I do so by just doing everything except mentioning his name. That can still potentially be defamatory. So this is... Yeah, and I see, isn't this basically telling the trial judge you done effed up 16 different ways? Kind of. But, I mean, they're now going, this is going to be heard by somebody other than the trial judge. So, and in some ways, I mean, this many issues is basically like saying, hey, we lost so badly that I don't know that that's necessarily helpful. But I got to, with this, I got to give my new hip flask a test. Oh, and I filled it with something awful. So that's going right into a Caesar. All right. This is a pickled bean flavored vodka. And it's not good, but it'll do all right in a Caesar. All right. Oh, and I see a fellow Canadian in Austria. Nice. All right. So next, and there's going to be a whole bunch of them. We're going to just go through things fairly quickly. The real action on this one is going to be when the actual briefs come in, because then we can start looking at their actual arguments and see if they can back any of this up with, something useful. He says, Sir Stroming Juice, if I brought that in the house, I would be divorced, and I like being married. So we're not going to do that. So the trial court erred in excluding from evidence at trial the November 2, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division in Depp News Group. I mean, I actually think that this was a perfectly correct decision, because how prejudicial is that going to be? And how, that's going to be super prejudicial. A jury's going to be like, well, another court already said this. But the jury's supposed to actually decide based on what they hear at this trial. What the evidence is at this trial, not a different other one. And I see Karen is asking, where do I get these odd spirits? I found this at a liquor store. I had a court appearance in a small little town. And so I stopped at this small town, and they had this on the shelf. I think it's a sort of local Alberta product. I don't recommend it. It's not great. So I'm not gonna sort of, show off, here's the brand you should get. Although if you want to know a brand you might like, that's a Canadian brand, Two Brewers, single malt. They pay me nothing, but I like this. So I got their innovative flavoring, and it was quite tasty. So, and it's Canadian. All right. And I see, a different trial where Amber Heard wasn't even a party. Yes, which of course is going to limit the kinds of things that that can be brought as evidence. The other issue on that is we actually see that the trial judge made a ruling based on a bunch of stuff we now are pretty sure is not true. Like, hey, he found it really, really convincing that Amber Heard had donated the money, that was a real bolster to her credibility because it showed she wasn't in this for money. Well, she didn't donate the money. She pledged it. And, as much as she says those are the same things, every human being on the planet knows that there is a difference. If you check out my Extra Life, there is 3,000 in donations. And that's going to the Stollery Children's Hospital. So if you want to throw some money at that, that's for a good cause. But yeah, there's a difference between donated and pledged. If I have been paid $20, I can go buy a beer with that. If somebody has pledged me $20, the bar doesn't take pledges. They just, So, and I see Sky is a Neighborhood. Thank you for the generous super chat. There's some irony in that they didn't bring up not naming him directly after suing him for saying something that technically didn't come out of his mouth. Yes, absolutely. So they sue him for Waldman statements. And Hogue has this. I already like for implication. My ex-pirate husband definitely didn't abuse me. Has to be actionable, even if true on its face. Yeah, I mean, there's certain times when stuff is, if you're like, hey, my ex-boss, touched me at work, right? If everyone knows who your ex-boss is, this isn't like, well, I didn't name the guy. It's like, no, but you said the thing. And so you got to be able to, to back that up. See Hogue saying, I'm definitely popping in, kids. I'm guessing that's kid wrangling there. Somebody saying, I bet the pickle vodka would be good for Bloody Marys, though. First of all, Bloody Marys are an inferior drink. Make a Caesar. Caesar better. I could go on a rant about that, but I'm always disappointed in the States when they make Bloody Marys. But pickle vodka is excellent in that. All right. So let's have a look here. I don't think that they're going to get much mileage on this one, especially given what we know now about that decision and how it doesn't really comport with the evidence that we've got there. Oh, I see Hogue saying for the charity stream, popping in for the charity stream. Absolutely. And I got to make sure I get that set up properly so that I can have people popping in and out. So we're going to make that happen. I just got to figure out how to do it exactly. So the next is the trial court erred in evidence from in excluding from evidence at trial medical records, including Ms. Heard's contemporaneous communications with medical providers, such as, and they list a bunch of people. Now, here's the thing. Let's sort of, what she wants to get in through this is, I told these various medical professionals that I was being abused at the time, which is hearsay. This is an out-of-court statement that she wants to admit to the court for proof of the truth of its contents, which is textbook hearsay. So this is basically saying they excluded all of the hearsay. They're not going to get this fixed, right? Because in order to get that hearsay in, you'd really need to have some reason why Amber couldn't testify. And of course she could testify. She did testify. She was awful, but she testified. She was able to go in and say, I would, experience these things. And so you can't just bring in all of these out of court statements. That's not how court works. I am pretty certain that the reason why this is in here is for the PR value of this. What they're going to do, and this is me pulling out my crystal ball here. So hold me to this if I turn out to be wrong. They're going to put in their brief all of these statements, and they're going to say this would have changed everything and so forth. And the reason why is that then we already know that Amber's got she's got excellent media game. She's got all sorts of, people in the media who she can, who she can contact. And those people will then repeat those claims from the briefs and say, look at all of this stuff. This is the PR game that we're seeing right here, point 5A. This is all PR. Because, I see somebody saying, WTF is a Caesar. Is it a drink? I know the salad and a person. Never heard it used for alcohol. Look it up. It is a cocktail. Basically, I didn't make it right for this because you're supposed to have a rimmed glass with, sort of celery salt or Caesar mix there. But it uses Clamato as the base. So it's akin to a Bloody Mary, but it's got Clamato. It's got some spiciness to it. It's like a Bloody Mary, but it's actually got better sort of umami flavor to it. So vastly better, in my opinion. But they're super popular in Canada. They are not very common in the States, but I recommend them. So, all right. So, and here's the other thing about, 16 points here. And somebody in the chat commented on this. I said, oh, I hope they do. That'll even up their page count with wasted, useless arguments. Appellate courts, you typically have a filing limit. And what that means is you've got X many pages and you can't exceed it. And I mean, you can sometimes ask for permission to respond to it with like extra pages, but they're usually reluctant to do so. So you don't want 16 arguments, because if you're going to make 16 arguments, each of your arguments is going to be kind of crap. So that's another reason why I think this has got to be PR stuff. But it also kind of forces the other side to respond to 16 points. You can sort of gish gallop them. So that might be what they're doing there. I see Caesar, vodka, Clamato, Worcestershire, celery salt rim, celery stalk garnish, or bacon strip garnish. There's all sorts of things people garnish this. I see people asking, is my stomach better? Yes, I don't know what happened. I suspect it was bad chicken. Really bad chicken. I hope to never have food poisoning like that again in my life. So, yeah. And Rob confirmed this morning, Virginia definitely has a limit. Forgot what it is, though, 50 pages or... I mean, just about everywhere has a limit, because appellate courts, if they let people, certain lawyers would file like 300-page briefs, which is not brief, right? The whole point of a brief is that it's a short, concise thing. It's... And I see somebody saying the Caesar was invented in Calgary, so take that, Edmonton. Listen, as an Edmontonian, I will concede that Calgary's got to have something good about it. So fair points. Hogue saying, I believe he said 25,000 were, yeah. So they got a limit. And those limits can be pretty harsh. I can tell you that here where I am, I have seen appellate courts literally do this, where they say, okay, you've got 30 pages. I've seen them get like a 45-page brief, and in the appeals court, tear off 15 pages of it and just say, all of these arguments, we're not going to listen to because you couldn't be brief in your briefs. So there's real risk to exceeding those page counts, folks. If you've ever wanted to see a lawyer make an unhappy face, watch what happens when the court says, we're not going to look at half of your brief because it's too long. All right. So B, and Ms. Heard's communications with several third parties, including Mr. Depp's employees and Ms. Heard's employees, friends, family, about interactions with Mr. Depp, including reports of drug use, aggressive and abusive conduct, physical abuse, and her fear for safety. More hearsay, right? If you want this evidence in, you either call Ms. Heard to testify and she could say all of these things that happened, or you call in the employees and they can testify as to what they saw. But you don't run a trial based on this stuff was said out of court and we're just reporting that it was said. Hearsay is a very important legal principle. And the reason why is because otherwise, if hearsay is admissible, it becomes very easy to convict people for stuff they didn't do. You know, let's say Bob wants to accuse Frank of a horrific crime. And so Bob comes to me and says, I saw Frank do all of these things. And then Bob goes into hiding. Bob is missing. But I go to the police and I say, Bob told me he saw all this stuff. And now the court, now the police want to charge Frank based on my reports of what Bob said. The other lawyer is going to try to cross-examine me on this and is going to try to shake my credibility. But I'm unshakable on this because I am 100% telling the truth that Bob told me these things, right? And Bob, if they had Bob there, they might be able to catch Bob in all sorts of lies. But me, I'm telling a very different story. This is why hearsay is inadmissible. It's really key. It's really important. And basically, she's just going, the rules of court that have existed since forever, I don't like them. Please make them stop. Again, this is PR. This is where we're going to see a lot of the PR ground game going on. And yeah. So the court erred in admitting evidence at trial related to Ms. Heard's pledge to donate money to charity and evidence related to Ms. Heard's alleged abuse of third parties. Well, you wanted to get the UK judgment in, and the UK judgment relies heavily on the whole pledge versus donate thing. And, she herself wanted to testify about how she gave away the money. So I don't see, this is basic credibility stuff. I told very public lies about what was happening here is basic credibility stuff. So I don't see how they're going to make out that this was an error. But, okay, I guess they're going to try. Trial court erred in excluding evidence at trial of Mr. Depp's reputation as it exists prior to publication of the challenged op-ed and after the op-ed was published. I'm not sure which evidence they're talking about here because, of course, it was excluded. But I'm guessing that they were looking to bring in some reputational experts and so forth on that. And they didn't get in everything that they wanted. Okay. Trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the allegedly defamatory statements on the grounds that it called for a legal conclusion. So let's talk about what it means to call for a legal conclusion, right? Witnesses are supposed to testify as to like facts, or if they're the case of expert witnesses, opinion. Like expert witnesses can bring in opinion. But what you can't do is bring in legal, like you can't just make ultimate legal conclusions, because the legal conclusions belong to the judge. The judge makes the legal decisions. And so this is actually, I'm going to do a video on polygraphs and lie detectors, but I'll give you a little bit of a spoiler. This is the reason why lie detectors are not admissible in court, is because it's taking away jobs from the jury in that case as a decision of fact. They can't, you know, the witness can't tell the court what the law is. That's the judge's job. So that's where this is upsetting. Sorry, you can hear the pups going nuts in the background. I'm guessing that the cleaner has just arrived, and they are super excited. They uh, they are big fans. So yeah, that's what we've got here. Michelle Price, thank you very much for the generous super sticker here. I really appreciate it. And I see here they got a load of headlines in about JD though. That's what this seems to be about. That is getting some headlines on this. See, happy pups. Yes, the pups are super cheerful, and every time the cleaner comes over, they're like, "Yay, we missed you!" And I love to see it, but they got to go outside here so that they can chill out for a little bit. I see here, how long can the appeal process go on for? Is there a point where it just has to come to an end? Yes, the courts won't let this go over forever. They will basically say, like, this has got to resolve itself. They're going to set timelines and deadlines and so forth. And so there will be a process. They will run out of appeals. I see, yeah, my cat Gur is definitely hearing them. Fantastic name on that cat, by the way. If that's an Invader Zim reference, thumbs up to that. That's amazing. All right, so let's keep going here. All right. The trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. And I don't think that really happened. I think that this is weak in terms of its foundation. But, I mean, okay, they're going to throw that and try to argue that. I see here, we saw a bunch of proffers during the trial. Is the brief where we could expect those to be referenced? Yeah, I mean, part of that is basically them trying to preserve stuff on appeal, right? To say, we preserve these issues. There's still things that we can argue. And that's because there's only certain things that you can't argue new issues on appeal usually. There's restrictions on that because an appeal's not supposed to be a new trial. I hope you guys aren't hearing too much of the vacuum in the background here. Yes, I'm seeing people saying, is that a vacuum in the background? One second. All right. Sorry, folks. I just we won't be long, but I've just asked them if the vacuuming can maybe hold off right outside my room here. Just all right. So we've got here. Sorry, I've lost my place here. Oh, right. Conduct prior to the publication of the challenged op-ed. I don't know which statements or if there's any indication that the jury actually awarded anything based on that. So that's sort of, I don't see it, but we'll have to make it. I'll have to see the brief to really properly evaluate this one. Trial court erred in allowing Mr. Depp to argue or suggest a trial and the jury to consider whether the allegedly defamatory statements in the challenged op-ed were republications of statements Ms. Heard made in 2016 in connection with a domestic violence temporary restraining order she obtained against Mr. Depp. I don't see how this is an error. I mean, republication of a statement can revive a limitation period or the like. So, yeah. And I see Hogue, Hogue is saying, yeah, they had more than enough space to make that value of damages in only after 2018. They only spent like, a long time in their closing on that. And they only like brought in several experts on this point. So I don't know how they're going to say that this is, something that was unfair to them. They got to make their argument. The jury got to make their call. And at the end of the day, it's sort of resolved there. All right. So what challenges does an appellate court have to deal with from a 6-week trial? Sifting through the transcripts must be hell for the law clerks. If you are writing a good appellate brief, first of all, you have to put in all the transcripts. So they've got all of that. But the other thing is, if you are good at writing an appellate brief, you are going to point them to specific things in the transcript. Because if you just ask the, if you just ask the court, like, hey, please review the entire transcript for this point, the appeals court is not going to be happy with you. And the last thing you want is for those justices to be pissed off, because at the end of the day, that's not a great strategy for winning. Let's see here. Not many people catch the Invader Zim reference. I'm extra impressed and happy to be in your chat. A fan of your. I am a huge fan of Invader Zim. It is a wonderful thing there. All right. The trial court erred in allowing Mr. Depp to argue or suggest a trial and the jury to consider whether the allegedly defamatory. Oh, wait. I just covered that one. Trial court, which rejected proposed jury instruction CC, improperly instructed the jury on actual malice. This I find kind of interesting because in their closing arguments, the Heard team improperly instructed the jury on actual malice. Like, they improperly suggested that that actual malice meant something like she hates him, which is not what actual malice means. That's not how this works, folks. See, question: are they going to bring up the juror issue? Well, I didn't review this in detail beforehand, but we'll see there. Elaine butchered malice. Wasn't that malicious? Yeah, it was. The thing is that legal terms don't necessarily have anything to do with what they sound like. I make this point sometimes. I've got a video about how somebody was charged for discharging a firearm with respect to a... fast work by Secret McSquirrel. Thank you very much. Discharging a firearm with respect to shooting a slingshot in a public park. And people were like, how could that be a firearm? Well, the meaning of firearm doesn't necessarily mean just a gun. The meaning of firearm is however they define it in that legislation. And that legislation said that a firearm is anything that shoots a projectile. So a slingshot would count. So actual malice doesn't necessarily mean like that you are a cackling, it's Halloween, so I'm having the vision of like a cackling witch, who's out to get you. It has a specific legal meaning, which was explained to the jury. And yeah. All right. Just looking here. Sorry, I missed something there. Is there any chance Elaine didn't know the meaning of actual malice, or was she being sneaky and underhanded? This is one of those things where it's like, I don't know, because some of the stuff she did seemed to be sneaky and underhanded, and some of the stuff she did seemed to be just not good at her job. So I don't know if she's being like a malicious law squirrel or if she's being just bad at what she's doing. I would have hoped she would have looked up the definition of actual malice before running a millions of dollar defamation trial, but I can't say for certain. So, yeah. I see Brentwood Sheik is asking, will we see you during Friday Night Frenzy with Rob later? I hope to be. I can't say exactly when. My wife and I have a date night planned, so we're going out. And I think that happens at the start of Friday Night Frenzy. So if he's still going when I get back, then I will absolutely pop in, because love Rob, always happy to be on there for that. But some things take priority, and wife takes priority. That's just the rules of the universe there. So sorry, folks. But I think I'll probably be on a little bit later in that, and we'll see that. And I see, so we get a Drunken Friday Night Frenzy. Yay. I'm going out for nice sushi, and nice sushi is great, but it's expensive to get drunk on good sake. So maybe not. But I do have, let's count them. 1, 2, and then 6 more hip flasks. So I am now well equipped to get perfectly sauced if that is my volition. The game plan on this is that I'm going to sort of build a leather case, and then there's going to be compartments that I've got like 8 separate, little things of alcohol, so that I can have a little bar wherever I go if I want to. So I see somebody was asking, did I get my wife's slippers fixed? I did. Now, the problem is that I fixed one slipper, and so the other one doesn't quite match, because the saddle stitching doesn't look the same as the machine stitching, but the machine stitching is so much better. So, yeah. All right, let's keep going here, because want to get through all of this. All right, so the trial court erred in denying the motions to strike and set aside the jury verdict with respect to Mr. Depp's failure to prove publication by Ms. Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath." That has to change. I mean, didn't she admit? It's been a while since the trial was going on, but didn't she admit she posted that? Like, didn't she admit that was her statement? So, yeah, I don't sort of see how that one goes. I see illegal bar. No, this will be a legal bar that I can just carry around to wherever I'm going. So if I'm going to a party, I can park this down and then mix myself drinks. That's kind of what I'm looking for there. I see bandolier of flasks always prepared. I'm just going to share a little thing about a plan I have. So you know how women's dresses are usually low on pockets? I actually want to get some really nice leather together and make like a fashion bandolier, and see if I can persuade someone to wear that. Just because a fashion bandolier, I think, would be a really awesome thing, and just amuses me personally. So yes. I see somebody saying, does a flask count as an open container in a car? Probably, yes. So, yeah. And she admitted it twice. Yeah, and she copied the link from Washington Post website and wrote a new tweet saying, "Today I published." Yeah, this one seems super weak. But hey, that's what they're going to be doing there. All right. The trial court erred in denying the motion to set aside the jury's verdict with regard to Mr. Depp's failure to prove that the allegedly defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Ms. Heard. Again, these are questions for the jury, right? In order to sort of strike that out, you've got to have... It's got to be so obvious, and I don't think it was. I mean, the jury was certainly able to say, hey, listen, this is a defamatory implication, and also that she intended that in, that's jury questions. And you can't just be like, oh, well, we don't like the jury's verdict, so throw it out. I don't see that that's likely. Trial court erred in denying the motions to strike and to set aside the jury's verdict with regards to Mr. Depp's failure to prove actual malice by clear and convincing evidence. Again, that's the jury's call. So, yeah. Somebody's saying, have I seen fashion shows? A leather bandolier will be shown with a nude model. Do what you like, but I just want to make the bandolier. So, she said, that's why I wrote the article about Johnny at the end of the trial. Yes. Ugh. Everyone who read that op-ed knew she meant Johnny Depp. Of course. I mean, so many people picked up. It was not subtle. It was not subtle at all. I see my roommate could make that for you. He makes and sells leather goods and more for Renaissance fairs, etc. I make leather goods. So I'm going to make this just as a project. That's going to be something I'm going to try to make there. All right. The trial court erred in denying the motion to set aside the jury's verdict and in ruling that the jury's verdicts in favor of Mr. Depp on his claims against Ms. Heard and in favor of Ms. Heard on her claims against Mr. Depp were not inherently and irreconcilably inconsistent. So basically, this is saying, hey, listen, because they ruled for Depp on some things and for Ms. Heard on other things, that this means that these are inconsistent verdicts. Now, I will tell you, the courts almost never grant inconsistent verdicts. This is something they're super reluctant to do. And in order to get to inconsistent verdict, it has to basically be completely and totally impossible. Like 100% cannot reconcile these two things. And I don't think that that is something we see in this case. In this case, there is the very real thing that they could say, listen, we think that the Waldman statement is defamatory because it implies a certain specific kinds of planning to make this up, as opposed to the, the Heard statements, which we think are defamatory because we think that the abuse never happened, but maybe we don't think that the specific degree of planning. The degree of planning involves further sort of suggestions of, in some ways, criminality, in terms of trying to mislead the police. So I don't see how these are irreconcilably inconsistent. I don't think this one's going to fly, but they're going to try. I see. Are you going to have more leatherwork for auction? I am. I'm just making a really complicated piece, and so it's taking me a while. I should knock out some stuff that's quicker too, just so that I've got some faster pieces here. All right, let's look at our last point here. The trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of the jury's damage award in light of Mr. Depp's failure to prove pecuniary damages and the excessiveness of the compensatory and punitive damages award. I mean, this is what juries do. Juries decide the value of that. So, okay. And I see a couple of donations. Bop it. Thank you very much. $5 for the Saki Fund. And Equality, thank you for the $5 for the Saki and Date Night Fund. I appreciate it. I see here. I don't think we were watching the same court as they were. Yeah. Now, there's one that I think, there's an issue here that I think is really interesting by its omission. Anyone seeing anything here about our mystery juror? Mystery juror is not mentioned at all. Remember how they made all this big noise about oh, this juror is not the real juror, and oh my God, this is such an unfair trial. That went away. That went away real fast. Yeah. That was BS at the time. They know it's BS now. They really don't want to put that into the appellate brief because, yep, I feel like they would get hammered on that one. I actually think Judge A was kind of nice in how she dealt with it, because I think that they could have really, she could have really hammered them on that based on the fact that they had a requirement to object and, that they were sort of trying to play malicious law squirrel on that one and hiding away issues for later. But yeah, they're not raising it now. They know it's not an issue anymore. So yeah. So I see here that was slapped down by new lawyers. I'm guessing the new lawyers were just like, we are not touching that. Do not at all. Hogue, I see you 1K in chat. That's awesome. Let's surprise Ian with some extra likes. Thank you very much. So, yeah. I see, is malicious law squirrel Secret McSquirrel's nemesis? I'm going to say yes. Secret McSquirrel is the valiant fighter of malicious law squirrels. So, yes, this was such a stupid argument at the time. It was such a bad argument, and now they're reviving this argument for no reason whatsoever. It baffles the hell out of me. Uh, but then they dropped it at appeal, and I'm so glad that that is not something we're seeing. But I mean, I guess they got what they wanted out of it. Remember how much media coverage that got? Ooh, this mystery juror, and there's a conspiracy and all of that. Well, yeah, that's gone. So, all right. And I see, is Amber Heard doing this because Hollyweird has turned its back on Amber Heard? I mean, I kind of feel that she is reaching for things because she's got to see her career is in some serious trouble here. And Johnny Depp, meanwhile, it looks like he's having the time of his life. He's going around, he's playing music. People are talking about what sort of movie deals he's going to do and so forth. This is the PR battle. This is, them waging a PR battle. So is Amber Heard doing this because Hollyweird has turned its back on Amber Heard? Yeah. And I see Amanda Howard. Thank you very much for the very generous super chat here. Can any of the points listed by a party be left out of a brief, or if they state them, then they have to be present? I can't say 100% for Virginia, but I can say for like everywhere here in, in Canada, just because you put the way you do it where I am is you'd have to actually put these points into a notice of appeal. So in order to get your appeal filed, you'd have to put these points in. And, but later you can drop points. You can just be like, we're not arguing this. And I don't think that there's any sort of harm to that. They could say, listen, we filed like 16 points, but we're going to argue these 4. It's entirely possible. So, and I see, hey ho, can't wait for Lawyers and Dragons tomorrow. Yes, I am nervous as heck about Lawyers and Dragons tomorrow, and I'll tell you why. We're doing a sort of divergence with the pilot characters. We're having a special guest, I hope. And I'm DMing it. And I can tell you right now, for no money, I am not as good as David at Prototopics. So he is, he's, better at that than I am. But I'm going to do my best on all of that, and we're just going to sort of see how this goes. And I think I need to turn on subscriber mode because we are getting the porn bots, and that's not something we want. So we're just going to flip that on. I don't think the chat's too bad. I don't think we need to throw on slow mode at this point, but we'll just, put that up just so that we're maybe not getting all those links that we don't need. So, yeah, I see Runkle will be the GM. Yes. And I will also tell you that there was going to be a special role of law that will follow that, which is going to be a bit of a behind the scenes as to what happened on that Lawyers and Dragons episode. So, so check that out. I'm nervous. I am excited. But I can say that I don't think there's a better group for it because everybody there is super chill, super, so if I am struggling, there's going to be people, who are sort of willing to not sort of ambush me on that one. And I see here, is David going on a retreat to get over his ROP disappointment? That's Rings of Power, I believe. Yes, I think he's in mourning. And I think he's actually at a secluded retreat dressed all in black with a veil in order to, to deal with that. So, all right. See this. I'm ready to debate you for advantages, Ian. Fair enough. I can throw down with the best of them. All right. So I see a question. Am I going over JD's? Yes, absolutely. And I see, will we have to use focus emoji? I get the point. Let's go. All right. So this, now you see here, this one is also listed as appellant's assignments of errors. The reason why they're both the appellant here is because they're both cross-appealing. Each of them is appealing on different issues. So each of them is filing an assignment of error as the appellant because they're both appealing. So that can be confusing to people because at the trial level, there was the defendant and the plaintiff, but now we've got everybody is an appellant and everyone is an appellee. And that's complicated. All right. So looking over things here, we've got, so appellant John C. Depp II, Mr. Depp or plaintiff, by and through his undersigned counsel, hereby submits the following assignments of error. All right. So first, trial court. Actually, I'm just going to sort of point to something here just because this is a peeve of mine. So you see how Amber Heard's team starts this? Comes now, appellant Amber Laura Heard. I hate this language. I will go on a rant about this language all the time because the point I always make is that this sounds like a 17th century porno. Comes now, appellant Amber Heard. It's like, does she now? Okay. I really much prefer the phrasing on the Depp team where they just say, appellant John C. Depp, by and through his undersigned counsel, hereby submits the following assignments of error. Yes, you are talking like normal people who are from this century, like that you didn't just fall through a freaking time vortex. And yes, plain language, please, in legal writing. Thank you. I kind of want to write them a thank you letter just for that phrasing. And I know Rob likes the other phrasing, and I kind of tease him for it. So, all right. So the trial court erred by denying, one, Mr. Depp's motion for summary judgment as to appellee Amber Laura Heard's counterclaim. So basically just saying you should have thrown out the counterclaim because it was some garbage. I don't think they're going to win that one, honestly, but why not argue it? And Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. Now, I actually think that I don't think they're going to win on this one, but I think they've got a stronger argument because the counterclaim is the Waldman statements. And the Waldman statements are kind of harder to hold Mr. Depp responsible for. So Mr. Waldman is an independent contractor, not an employee agent, and Mr. Depp is not liable for Mr. Waldman's allegedly tortious conduct as a matter of law. I think there's a really good argument for that. I see here, I bet I need a whole Runkle rant on antiquated legal language. We'll do that sometime. I'm not going to get too sort of divergent here. And I bet Rob writes it as old Virginian voice, Rob. This is going to be my own personal headcanon on that one, is that every time Rob starts out writing his legal thing, in his head, that's what he's doing. And you're never going to convince me otherwise now. So that's how we go there. And I see the Virginia loves its comes now. And that doesn't surprise me because Virginia's slogan is apparently Virginia is for lovers. So the comes now appellant, whatever fits in with that. I'm going to cut it off there before YouTube strikes me for being too spicy. All right. The claimant's counterclaim statements by non-party Adam Waldman, Mr. Waldman, that are the subject of Ms. Heard's counterclaim are not actionable statements sufficient to support a claim for defamation. Honestly, I think that one's debatable. I don't think that's the strongest point on this one. And, so for everyone out there who says, oh, you just always, simp for Depp or whatever, I think that if you establish that there's the agency relationship, then it's reasonable for a jury to conclude some defamation aspect on that. And I see lawyers that aren't in-house have to be independent contractors. I sure as heck don't get employee protections for my clients. Yes, 100% on that. All right. Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. That I think is also a fair point, because how do you show actual malice from Waldman, who's potentially got all of these, he's got all of this information that he's looking at. How do you show that it's not his interpretation of that? All right. Now here they've got this big block of text, and I like and don't like this big block of text at the same time. I think this big block of text is bad for the PR aspects. And as I mentioned, there is a PR battle on this. The thing is that this is also really sensible because they're showing, where they say preserve plaintiff's memorandum to sustain demur, plea and barred all counterclaims, and so forth. What they're doing here is they're saying, listen, we argued these issues. These are genuine points at appeal that are preserved and protected and so forth. And they're pointing the court to the specific places where that happened. This is good practice to say, listen, this is where all this went down. I like this. It doesn't read well for like this stream. I'm not going to read this entire block of junk out, but I like that they did this. They say, right, Ian, I think Waldman might have defamed her, but I really think it's hard to attach a lawyer's statements to the client absent proof of orders. Yes. It's kind of madness to assume that just because your lawyer is talking about a case that they necessarily had directions on that they necessarily were acting on instructions on that, because lawyers are people and they do things on their own, right? So most of the stuff I say on this channel, well, in fact, all of the stuff I say on this channel is coming from me. I don't have clients that are saying, go make a statement. And in fact, if a client said, hey, I want you to use your YouTube channel as a platform for my case, I don't think that's something that's for sale. I just, you guys really rely on me to be presenting information that is, neutral and unbiased. And if I start selling my YouTube channel as like, hey, I'm going to make comments on behalf of my clients that have to be specifically what my client says and what my client has reviewed, then that's not the case anymore. And I would be betraying you guys if I did that. So, yeah. Anyway, I really do like that they point to all of this stuff. It is, in my opinion, this is good practice, because if the appellate court later comes back to say, whoa, where did you preserve that? You're like, it's right there. That's where I preserved that. This is a genuine issue. CEO Hoglaw is saying, most of my clients are like, you have a YouTube what? Yeah, I get clients who don't know that I've got a YouTube channel, and I get clients who are like, Runkle of the Bailey. It's there's actually a transcript out there where my client, upon getting a ruling that they liked, shouted out in the hearing, Runkle of the Bailey. And the funny part is that the court official who was presiding over that hearing had no clue. They were just like, what? Because they didn't know I have a YouTube channel. So that I was just like, this is kind of embarrassing. Clients, please don't shout stuff out in court. You don't shout World Star. You don't shout anything. Just like, oh, yeah. All right, so let's go to the next thing here. The trial court erred in refusing Mr. Depp's proposed jury instructions numbers 22, 23, and 24 as to whether Mr. Waldman was acting as an independent contractor when he made the counterclaim statements. So this is connecting to the first issue, right? Is Mr. Waldman an agent or is he an independent contractor? And there's a distinction there. And I mean, that is something that I think the court could say, hey, this is, a real sort of substantial issue. Now, I need a second because it looks like I did not save all pages here. So I need to go and grab one more page. And I got to say thank you to the always wonderful Andrea Burkhart for putting this stuff up here, because I'm relying on the stuff she posted online. Check out her channel. She does excellent legal commentary. She's one of these people who I think she basically never speaks off the cuff. And what I mean by that is every time she talks about something online, I kind of feel it always feels like she's done like 6 weeks of research on it. Even when it's something that just came out like last week, it feels like she's done 6 weeks of research on it. So I always really like seeing all of that stuff there. And I see here, what's this? I think it was a ploy to get Waldman off the U.S. case. Yeah, I mean, they're making him a witness so they can kick him off the case. Seems like a real possibility. Waldman, from all accounts, is an absolute legal badass. And that is, one of these guys who's just an absolute force of nature. And yeah. And what is it? That Waldman made it in would suggest there's a chinwag behind closed doors where Depp told him, I didn't instruct you to do this. You pay it. I mean, I don't think Depp is the kind of guy who's going to come after Waldman for, out of vengeance or anything like that. I just, I don't see that as an issue there. All right. Is your sleep paralysis demon a client screaming Gimlet's full name? Well, it is now. So, and I noticed Canadian court filings are in first person and easier to read. Canadian court filings have really embraced a lot of the plain language stuff, and I love that there. All right. So let's have a look at the last page here. So proposed jury instructions, which the trial court denied on May 20th, 2022. And the trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibits 88.1a, 88.1b, and 88.1c, which are copies of the news articles in which the counterclaim statements appeared, instead admitting only redacted versions that showed the counterclaim statements out of context. I actually think this is also a good issue, and this is partially because here's the thing. The reason why they excluded all of that other stuff is because the entirety of those other articles is other people's comments, like other stuff that's going on. And I'm just going to see if I can bring one of those up here just so that you guys can see, just to, have a look at one of them. All right, let's see if I can bring that up here. Sorry, folks, I'm still kind of figuring out the whole StreamYard thing here. All right. So here we go. I see here, Apple Pie, a humble donation to make up for giving you a new sleep paralysis demon. Thank you very much. So this is the article, and you can see, I'm not going to read you the full article here. I'm just going to show you the article here, just so you can see how long it is. And, it has comments here from Mr. Justice Nickel, which was excluded for other reasons, but also David Sherborne. There's various other witnesses, spokesman for Ms. Heard, and so forth. Talking about the rum diaries, talking about, other things here. Ms. Heard is not a victim of domestic abuse. She's a perpetrator, the U.S. suit claimed. You can't find defamation in this because this would be covered by litigation privilege, assuming that these are part of legal filings. So, yeah, there's all of these, sort of aspects about the filings and so forth. They got tape recordings about all of this. And so it just goes on and on and on, talking about all sorts of things. Mr. Wolanski says this, Mr. whatever else says that. And finally, there's this bit right here. So Adam Waldman, Mr. Depp's lawyer, said afterwards, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and a shield, depending on their needs. The jury, all they saw was like these lines right here. But the rest of the article, I mean, there's a good reason to say that a lot of this should be excluded. but it's also very hard because defamation has to be examined in context. I see we've got somebody for the 9 Inch Nails Gals 1994. Glad to have you on the replay crew here. And Jenny, thank you very much for the very generous super sticker here. But the problem is that defamation does have to be examined in context, right? And so I'm torn on this one. I can see this one both ways because some of that stuff that's in there certainly I think should not have gone in, and some of this stuff I think So I waffle on this one. I really want to see the briefs on all of this, and the problem is that we've got all of this stuff here as to everybody's like, oh, this is the briefs, and it's not the briefs. And so people were saying, hey, you've got to you got to comment on this. And I'm going, this is just the appetizer, right? This is the little tiny little bit of food they bring you before the real main course. And this is kind of like going to a restaurant and you get the appetizer and they say, okay, there's going to be a little delay for your meal. You go, okay, how long of a delay? 30 days. You wouldn't be happy with that. And so I feel like this is kind of just whetting my appetite for the main event. And then it's going to be so long until we get the actual main event. Let's see, can you read the statement and see what is missing in context for us? I mean, I've got the statement here, in terms of that. But at the end of the day, like, there's so much stuff here in terms of what else is going on. So yeah, it's there's a lot of stuff here. There's so much stuff in these articles that I just can't possibly go through them. Anyway, so that's kind of that. I'm going to sort of wrap things up here, and just so if anyone's got any last minute questions, now's the time. I think I've got a couple of super chats here that I wanted to cover here. Leanne G, thank you very much for the $10 super sticker. Much appreciated. Didn't want to miss that. And LB Messimer, didn't see anything about freedom of speech. Wasn't that a talking point in their closing? It was. And I think that it's going to be a talking point in their, I think that's going to be in their brief, the freedom of speech issues, but it's not spelled out as a freedom of speech issue in their points at this stage. I think it's going to be rolled into some of the other things about like why things should have been struck is because of freedom of speech issues. So I think we're still going to see the freedom of speech arguments. I think that they would be crazy not to. I mean, that's what they've got to argue some of that. But yeah. And I see here it was the statement with the wine and the police. Where do we find the article? So where you find the article is if you go on the Virginia court page, there's a section for basically high public interest. I forget what they call it. Court cases. And right now there is one court case still listed, which is Depp and Heard. And on that, you're looking for the counterclaims document, which and it's filed as exhibits on that. And the other place to get it, if you want to go directly to it, because I got to give credit here, is if you go on the real Laura B's Twitter, she's where I got that point. And she links it directly, so you can go and it's like exhibits E, F, and so forth. So I see, what are the odds she gets an appeal? She gets to appeal, like she gets to challenge it. I just don't think she's likely to be successful on this. I don't see anything. There's nothing, at the time of the trial, I thought this is pretty solid. There's nothing that they put in their notes here that really makes me think, oh man, they're changing the game here. They're really going to step this up I think that they've got a really good issue here. What I see is a lot of PR wrangling. And so I kind of have the feeling that where this is going, if I'm being a little cynical, is I kind of feel that she's going to run this knowing that she's likely to lose the appeal. And she's going to run this for the purpose, in part, of getting this all basically to portray herself as a victim in the court of public opinion. She's going to say, look, I had all of these really good issues on my appeal, and the mean old justices, like the mean old appeals court, still didn't grant it. And I think that they're going to be really, I think that Amber's PR team right now, I think their fondest hope is that this gets heard by a guy. I actually suspect that they were probably really pissed that it was Judge A that heard this one, because I suspect that they wanted to, to make all sorts of sexism arguments. And Judge A is the wrong judge to be making that about, because they were sitting there going, oh, it's good. It was this old white guy. And it's like, sorry, you didn't get that. So I think they're going to be, yeah, I see Hoag's got it exactly right. The system kept her down and doesn't listen to women. Yeah, that's, yeah. And I see, did you know Prince Harry, Elton John, and a bunch of others are currently suing the Daily Mail? Seems they wiretapped, went through trash, and fabricated info for stories. Easy to invalidate them. I haven't looked at that lawsuit. I've seen the newspaper coverage, and I'm super reluctant to comment too heavily based on newspaper coverage, because we all saw how the media covered the Depp and Heard trial, and I can tell you, they're not any better at anything else. There's like news coverage of court cases is typically really awful, but the allegations seem super wild. And if those allegations are made out, which of course is going to be a challenge, I'm really interested to see what evidence they've got. I mean, that's real bad for a news organization. Although, to be fair, the Daily Mail's reputation is not really one of being a news organization. The Daily Mail's reputation is not super great. So, yeah. I see. How would she fund the lawsuits if the judgments from the original bond are held, or original trial are held in bond? They're not. She had to post a bond if she wanted to prevent Depp from seeking to claim on this. And Depp, I mean, she is once again really relying on the fact that Depp is a stand-up guy, because Depp has basically not, so far as I can tell, pursued any enforcement on this. He's made statements along the lines of, hey, I don't want to take money out of her kid's mouth and so forth. Because for Depp, it's never really been about the money. It's been about vindication. It's been about being, tell the world, Johnny, tell the world that you, a man, are a victim of domestic violence. That's what it's been about for Depp, is about tell the world, Johnny. And he got that. He got the world to see. So, he hasn't really been looking for the money on that. He's been looking for that, that vindication. So she basically has been able to rely on him not pursuing that to not post the bond. Because, Depp is a better man than I am. If I was in Depp's shoes, I would be going and looking for every dollar that, I'd be shaking her entire financial portfolio upside down for every dollar that could fall out. And like, hey, let's seize her car. Let's seize, if she sets down an expensive purse for too long, I'd have, a legal, I'd have a bailiff there to seize that. Like, but that's not how he rolls. Depp is a nicer person than I am. And I feel that she has taken advantage of that at every stage, including now. And that pisses me off, but it is what it is. I mean, if I could, I would be, I'd be going to town on this. I would have, like, if I was Depp, I would have my own law. Like, I'd have a separate law firm whose entire job is just to take everything that they can and give it to charity. It'd be like auction, Amber Heard's Louis Vuitton purse, and I don't know which brands she liked, but, going to fund the children's hospital that she pledged to and didn't donate. Like, absolutely, that's what I'd be doing. So, see here, Rifka Mohammed. I hope I got that right. I'm not sure where that currency is from. I got to look that up right away here. Only ever part of the replay crew. Glad to catch this live for a change. SAST sucks for your streams. Yes, I normally do stuff sort of late at night, and I kind of thought I'd mix it up today, both to sort of work around the date night and the what is it? Oh, and that's South African. Oh, cool. Both to work around date night and also to work around Friday Night Frenzy, because I really don't want to. I kind of want to be on Friday Night Frenzy. That's kind of my thoughts rather than competing with it. So, Granny Weatherwax, fantastic reference. Fantastic. Love it. Do you think she'll have to pay her insurers back all the legal fees if she loses the appeal due to actual malice finding? God, I hope so. Because Depp, I already mentioned Depp is the nicest person on the planet. I can guarantee you that the insurance companies are not the nicest person on the planet. So they will go after every asset they can find. So, yeah. And Andrea Burkhart pointed out that since he pretty much has to collect in California, and the reason why he has to collect in California is that's where the money is. Their laws prevent collection before appeal is done. Oh, that's good to know. But yeah, collections is its own area of law. Basically, it's its own complicated thing. So yeah, check out Andrea Burkhart. She is fantastic. See, yeah, that insurance company will not play games. Insurance companies, they are really good at not spending money, which is not really what you want in an insurance company, right? Because you want the insurance company to pay you if you have an insurance claim. But yeah, they go to town. So yeah. Secret McSquirrel, if he doesn't collect it, they will forever claim it's because he beat her. Yeah, that is a concern there. Love Terry Pratchett in Discworld. I can tell you, I have a copy of The Color of Magic, which is not my favorite Terry Pratchett book. It is a good Terry Pratchett book. I like it, but it's not my favorite. It's really before Terry Pratchett fully comes into his sense of humor. And so it's a different sense of humor than some of his later works. But I read the hell out of that as a kid. I read that over and over and over again. Yeah, Terry Pratchett will always hold a special place in my heart. And yeah, it's I'm a big fan. He also had the coolest sword ever with meteoritic iron in it and so forth. So I would love to be able to duplicate that sometime. My vintage fairy tale show is no competition for Friday Night Frenzy. You're always welcome to come on and read Hansel and Gretel, etc. That is actually really cool. We got to make that happen sometime, although I don't know if tonight is the night. So Sean H says, I've only read Color of Magic, need to read more. I very much recommend Going Postal is probably my favorite of his books. And it might not be everyone else's favorite, but I think it's mine. And I see, so not a fan of Leonard. I haven't actually watched Letterkenny. So I should fix that. I also want to cover some of Trailer Park Boys. There's a couple of Trailer Park Boys episodes that I want to do kind of a legal review of. So that's something I want to see happen. So, all right. Just seeing here. Somebody was saying that they have a leather-bound, a set of leather-bound Terry Pratchett books, like the complete works. I would love to do like my own set of leather-bound Terry Pratchett books, and that might happen at some point. Where is the best sushi in Edmonton? one of two places. I recommend Sushi Toshi, that is up near up near the North Edmonton Commons. It's in that sort of mall there. It is really hard to get a table there, but it's good stuff. Mikado Sushi, they've got several locations, is also really good. I Heart Sushi, or I Love Sushi, is good. There's a few good places. Now, I should say, I'm talking about good by the standards of Edmonton sushi. Now, I came from Vancouver, and Vancouver sushi is freaking amazing because they are right at the right at the water. Everything is super fresh, and the Vancouver food scene. Vancouver has so much competition on the restaurant scene that if you can't um, both do really good food and really inexpensively, you will go out of business. So Vancouver's food scene is freaking amazing. I see here, please do a viewing. I won't be able to go through the whole episode because, of course, then I will hit a copyright strike. But I can talk about certain scenes and so forth, and I think that'll be fun. So, see, one thing I hate about living in the middle of nowhere, closest you could find to a sushi place around here is a bait shop. I've actually had sushi from a like catch the fish and then turn it into the sushi, and that was amazing. So you can still have sushi that is fantastic out here. Absolutely love Carpe, Jugulum, Weird Sisters, and Soul Music. And Mikado Sushi is a really good rating. Yes, Mikado Sushi is fantastic. All right, I'm going to let you guys go. Thank you guys all for joining me. I really do appreciate it. I love the vibe in the chat. I love that it's all, happy, positive energy. It's I feel like that is the greatest gift that I've had sort of out of doing all of this, is that I get to sort of interact and chat with you guys, and the people I've met and the people I've sort of managed to sort of surround myself with in this is a real treasure, a real treat. And come join me for Lawyers and Dragons tomorrow, and and Friday Night Frenzy tonight when I can make it on, assuming that Rob is still going at that. So thank you guys. And I see last minute request. Will you cover the January 6th hearings? Probably not. I mostly focus on Canadian law, and I'm behind on that. There's lots of other people who are covering the January 6th hearings and probably doing a better job than I could. So that's kind of that. And Prince Rupert, BC is a sushi restaurant that rivals Vancouver and is one. Send me a DM with that name, because I might travel to Prince Rupert sometime, and I would feel bad if I missed that. So, yeah. All right. Talk to you guys later. Have a good one.